Good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, 21 CF 1848. May I have the appearances, please?
Good morning, Your Honor. Sue Opper, Zach Wichow, and Leslie Basie appearing for the State of Wisconsin.
Good morning.
Darrell Brooks appears in person in custody with his attorneys Anna Keyes and Jeremy Perry. Good morning.
Good morning, everyone. Court will go through a number of things here today. The first, I'll just let you know, I want to go through the letter that the state recently filed and some information related to that. Following that, I want to talk about scheduling of the motion that was filed by the defense. I'd like an update on discovery and where the parties are at with that, and then a few other procedural things as to whether there are any motions, other pretrial motions contemplated by the parties at this time, of course, scheduling of the next court date, and then any other issues the parties wish to address. As the parties are aware, the state filed a letter on the 7th advising the court, or wanting to make the court aware that I had some familiarity with the father of victim C. Victim C is one of the homicide victims, and under the statute, the father of a deceased is also a victim, so I felt it prudent to seal that letter to myself be in compliance with Marcy's law. As everyone is aware, that is a requirement that applies not just to the state when they file documents, but to the court, to the parties, etc. And so I did have that sealed, but I also ordered it redacted so that a redacted version could be made part of the public record, and it's my understanding that has been done. I wanted to make some disclosures out of an abundance of caution and as encouraged in the comments to Supreme Court Rule 60.04 sub 4, which talks about notification of information on the record to the parties when that information might be considered by the parties relevant to the question of recusal. First and foremost, this court believes it absolutely can and will be fair and impartial to both sides in this case. Here are the facts, though, that I want the parties to be aware. The court is familiar with the father of victim C and his wife. I am familiar with the father because I worked in private practice from September of 2005 through the end of 2011. I worked in a law firm that was located in the Seatman Realty building, and for those in Waukesha know that's on the corner of I-94 and Pewaukee Road. There are a number of law offices in that building, and the father of victim C had a law office as well. I was not formally affiliated with him, and at times his wife would work there as well. So that is how I know the father of victim C. We were in the same building, but again, not officially affiliated. I did have this person, the father of victim C, do some estate planning for my husband and I back in 2012. Our will, trust, things of that nature were finalized in March of 2012. We paid for that legal work. It was not free. In addition, the attorney, the father of victim C, also did some business work for my husband, some work related to the formation of a business in 2015. Now, we have since transitioned to a different firm and a different lawyer, and it's also my understanding that he is now retired. Again, we paid for that legal work. It was not free. The last time the court communicated with the father on any legal matters was in 2018 when I asked him a question about the business formation by email and some related work, potential work related to putting a home that we had in a different name. Again, that did not result in any work being done. He did respond by email. I also want the parties to know that on February 8 of 2012, this attorney did make a contribution to my Jennifer Dorrell for judge. As most people in the courthouse are aware, I was appointed at the end of 2011, took the bench in 2012, and this person made a contribution in the amount of $500 on that date. Now, I did not maintain any regular contact with the father of victim C. To my knowledge, I have never met victim C. I did have a very brief text message exchange when I learned that his daughter passed away, and I extended my condolences to he and his family on a text between myself, him, and my husband. I think it is interesting to note he had to ask who it was on the other end of that text, as my name was not in his contacts. It was a very brief exchange, and nothing else has been exchanged since. It is my opinion that these facts do not require mandatory recusal either under 757.19 of the Wisconsin statutes or Supreme Court Rule 60.04. Of course, all of that applies to me because as a judge, I am bound by those requirements. There are 7 scenarios that are described in the subsections A through G of 757.19 sub 2, which require a judge to disqualify herself from a criminal proceeding. Subsections A through G do not apply with the facts that I've provided or any of the scenarios that are described there, and so I won't spend any time going through them. The only question is whether subsection G applies, and if the court determines that for any reason she cannot, or it appears that she cannot act in a fair and impartial manner, the court should recuse. Of course, I've now provided the parties with the facts about my knowledge of the father of victim C and his wife. I would also acknowledge that these are non-exhaustive circumstances, meaning the ones that are specifically enumerated in 757.19 and also in 60.04 sub 4 of the Supreme Court rules. In the comments and other parts of that Supreme Court rule, there are examples of when, for example, a judge should recuse. One of the examples, for example, is when a judge is in the process of negotiating with a law firm for employment, the judge would be required to recuse herself from any manner in which that law firm is appearing before the judge. As I indicated previously, I do believe, and I will be fair and impartial in this case. I hold no bias in favor or against any of the parties here, including Mr. Brooks. A bias or prejudice requiring recusal most often arises from a prior relationship, but may arise from a strong personal feeling about the alleged conduct of the party. Again, I don't have any strong personal feelings about the alleged conduct of the party, meaning Mr. Brooks here. And although I have a prior professional relationship, I do not have a current relationship with the father of victim C or anyone in his family. As I indicated, I have not maintained any regular contact with him since our business professional relationship in 2012 and in 2015. Again, the last professional contact with him was in 2018. I do not believe the extension of condolences to someone that I once knew reflects any bias regarding this case. Again, I maintain an impartial view of the parties and their respective interests in this case. I'd also point out that this court is in a unique position with its prior work experiences, both 4 years with the district attorney's office as an assistant DA, and then 7 years as a criminal defense attorney here in southeastern Wisconsin. And that's only part of my experience. And I've, of course, been on the bench now for 10 years. I also took an oath. I've taken that oath now twice. Once when I took the bench, actually 3 times. Once when I was appointed, then when I was elected following that appointment, and then again when I was reelected. That oath states in part, I will support the Constitution of the United States and the Constitution of the state of Wisconsin, that I will administer justice without respect to persons and will faithfully and impartially discharge the duties of said office to the best of my ability, so help me God. That is an oath I take incredibly seriously, and I am committed to acting impartially in every case that comes before me. The Supreme Court rules are also very clear that a campaign contribution does not affect the court's ability to be fair and impartial. It is not a situation that requires mandatory recusal. I'd also point out that I was elected not once but twice by the people of Waukesha County to hear cases such as this. And I believe I was elected because I do have a reputation to be fair and impartial. Of course, my subjective analysis is only part of the analysis. There should be an objective analysis as well. I would also note, again, in addition to the oath that I've just taken and my responsibility as a judge elected by the citizens of Waukesha County, that a judge is also presumed to be free of bias or prejudice. And I'm quoting from State versus Santana. That's 220 West 2nd, 674, a Court of Appeals case from 1998. There are many other cases that discuss recusal that I have reviewed as well. I do not intend to go through them here today, but I have reviewed them, and what I can tell you is I have not found a situation such as this. Some of those cases talk about campaign contributions, others talk about a relationship or some type of knowledge or statement and things of that nature. In this case, it is my constitutional, it is my ethical responsibility to preside over the cases that are assigned to me. That is also from the Supreme Court rules, also found in 60.04 sub 4. And so because of all of that, and despite the disclosures that I have identified here today, I am going to remain on this case and not recuse myself, as I do not see it is required under either the statute or the Supreme Court rule. I do not expect the parties to respond today. I realize you may want some time to digest what has been disclosed. Talk to, of course, Mr. Brooks, and of course talk to the victims as well. If either of the parties believes after that disclosure that a motion is appropriate, then I trust you will file the appropriate motion. I would simply ask that that be done within a week. With that, I would like to proceed with discussing at least the scheduling of the motion that was filed by the defense. I have a question as it relates to that, and is there any part of that motion that the state were to agree to? And I'll be very frank with that. Part of that motion, of course, deals with a change of venue, but there's an alternative that's being requested, and that is a jury from outside the county and sequestration. Those are two things that this county is not unfamiliar with. There is some precedent for getting a jury outside the county. That was in the Oswald case, and of course during one of the cases that we sometimes refer to as the Slender Man case, when one of those cases went to trial, that jury was sequestered. So I wanted to know if the state would agree to any of that, and maybe focus my attention on the motion otherwise.
That would be our alternative position, Your Honor. At this point, based on the filings that we've reviewed to date, we do intend to challenge the motion and ask the court to make a determination.
On all counts? Or is there any agreement that a jury from outside the county and or sequestration would be appropriate in this case?
Not based on the filings we've seen so far, Your Honor.
All right, thank you. Then that helps me as I address that motion and deal with scheduling. I would like to have the parties brief that. I do think it's important, though, if there were to be any conversations and discussion among the parties, if there were to be any agreement. I don't know if that would satisfy the defense at all. For example, if there were an agreement to get a jury outside the county and an agreement to sequestration, if that would matter to you as well. I'll leave that to the parties to discuss. As the parties, though, do their briefs on this topic, I do think it's important that the parties address the impact of Marcy's Law. That certainly is a relatively new constitutional amendment. To my understanding, I've done some research on the motion for change of venue. I don't believe there are any cases that would address that aspect, but I do think it's something this court must consider in the change of venue motion and the alternatives that are being requested. So I know the defense has filed more than a boilerplate motion. There's significant reasoning and basis for that, but that is just one piece I'm going to ask that you also look at and supplement with. The other question, though, is when is it appropriate to address that motion, right? I know the defense needed to file it by arraignment, and that's why it was filed. Is that something that the parties believe this court should address sooner rather than later, or only when we get to a point where a trial would be scheduled? State, have any thoughts on that?
Certainly the passage of time is one of the factors that the court should consider when weighing this motion, so I understand the logic in that, Your Honor. However, I think there is the ability for the court to move even pretrial proceedings to another county if the court felt that was appropriate. So for that reason, I would say sooner rather than later. Also, I think it's prudent to, I know you're going to want to hear about discovery, I know you're going to want to hear from the defense, but realistically, we're sitting here, it's March. I don't think there's any reasonable way we could try this case in November or December. So we're either talking about a trial date in October or in 2023. And I don't want to get too far ahead, but I think having that end date maybe help us work backwards to decide when this change of venue should be addressed.
All right, I appreciate those comments. Let me hear from the defense.
In terms of when to decide the change of venue motion, I think it should be addressed, in terms of if court's ordering briefing today, I think that should be addressed sooner rather than later. The passage of time does show up a lot in the appellate decisions on change of venue. Of course, those are appeals after convictions when change of venue are denied. And so then it's a different assessment in terms of how did voir dire cure things. But I think just the procedural mechanism for this is it should be addressed kind of earlier on in the case.
I don't disagree with that. I also believe it does not preclude this court from putting the matter on the trial calendar and then backdating from there so that it can happen prudently and in due course. So with that, of course, when we have a trial is somewhat dependent on the review of all the discovery. I would imagine it's quite voluminous, so let's talk about that. Attorney Opper, is the state still collecting discovery? Do you have everything, and what have you turned over at this point?
Could I ask Attorney Basie to address this issue,
yes,
please?
go ahead, thank you.
All the paper discovery has been turned over. I believe that there are some videos I know videos have been turned over. We are going through the entire box of discovery on Tuesday to make sure that the defense has everything. I do believe they're missing some videos and some cell phone downloads. But in terms of the reports, I believe that they do have all the reports.
When would the state be in a position to try the case? I'm guessing, based on your comments, as soon as October.
Yes, we had identified a window of anywhere from the middle of September to the middle of October, Your Honor. That's still 6 months from now, and I believe Attorney Basie thinks all remaining discovery will be turned over next week, so that would still, again, be a six-month window.
And you've consulted with victims on that as well?
Not on that specific issue, Your Honor. Generally, we have talked about scheduling, and I think they understand the size of the case and the volume of the materials and things like that. So I have not specifically addressed with them this range of dates, but generally they understand this is a trial that will require significant preparation in advance.
I would note neither party's filed a speedy trial demand at this point.
Correct.
All right. Attorney Perry on that issue.
We are reviewing discovery as it comes in, but as you reasonably guessed, it's a lot. I think that if we're talking about October, that's probably fine. If we're past October, I think the earliest that we'd be available, just calendar-wise, we'd be looking at probably March of next year.
I forgot to ask a very important question, and that is, how long does the state anticipate this trial will take?
We're estimating 5 to 7 court days for the state's case in chief, Your Honor.
Have you thought about how long it might take to impanel a jury?
2 days?
So roughly 2 calendar weeks.
Yes.
If I add that, how long do you think the defense would need?
I don't know. I can't answer that at this moment.
Can you reason why setting aside maybe 6 weeks? I say that because my intent would be to do a trial from a Tuesday to a Friday, depending on, I thought about that in some other cases where I've done 2 weeks and I do a Tuesday through a Friday and I give the jury off on Monday. It's a little different if there's sequestration, and then we have to be mindful and go all the way through. But at least a month is what I'm hearing. I realize that's not your case, but if I balance maybe what the defense may have, do you think that's reasonable?
I think, in my opinion, Judge, 6 weeks is excessive. 2 to 4 weeks is reasonable.
Anything else on that particular topic, Attorney Perry?
No, not this morning.
October is actually a really good month because I don't have any chief judge meetings that month that I would have to miss. So that would be a month I could target and could set aside here today. I agree with the state that 2 to 4 weeks, but to be on the safe side, I would block off the entire month of October at this point and then adjust accordingly if after the defense has had more time to digest all of the discovery, do any investigation that they need, we can adjust. So October 3rd is a Monday. I would do this as a special Monday start, not to conflict with any other normal Tuesday trials that we hold in Waukesha County. 4 weeks would take us to the 28th.
Recognizing that this could change.
Yes.
No one here has said they have an outright immediate problem with October.
Thank you.
Thank you. Does that work for the defense?
Yep.
All right, so we'll set this for 4 weeks, beginning October 3rd through the 28th of October. This would be one where I'd want to hold a jury status a couple of weeks in advance, if not a month in advance. I think that's appropriate, looking at Friday, September 2nd in the afternoon. I would just block that all off to address trial motions in limine.
That's fine with me, but I think that is Labor Day weekend, if that matters to anyone else.
Right, sorry. I think the 9th would be fine then. Does that work for the defense?
That's fine.
Ms. Dunn, anything you want to say on that?
No, Your Honor, we'll go over all these dates, and there are a lot of people who aren't here that will
Right.
work best to.
So Friday, September 9th, 1:30 would be the jury status. As the parties know, I work on trial orders, which I will work on later and then upload with some standard due dates for pretrial motions, things of that nature, the motion to change venue aside. Realistically, for the state, because I presume you've been looking at the change of venue motion, when would you be in a position to file a response brief?
I will answer the court's question, but I'd also like to make a comment, please.
Go ahead.
So in discussing this, we have developed an idea that we'd like to propose to the court and to the defense team. We just discussed this morning, so I have not had the opportunity to speak to Attorney Perry and Attorney Keyes about this off the record. But part of the concern, obviously, we all recognize there could be a problem in paneling a jury from Waukesha County. And my comments earlier were, what I've seen so far, I'm not sure we're there yet. We propose it may be extremely helpful to send out jury questionnaires very far in advance. Like maybe if the clerk's office can identify the panel, send out jury questionnaires by like April 15th with a return date of June 1st. And we can ask many of these questions, and this is one of the remedies that the cases talk about as far as extensive voir dire can cure a problem with a panel. Our idea is try and screen as many people as we can with the significant questions, if anybody's donated money, if anybody was at the parade, if anybody knows somebody who was injured at the parade, things like that. An initial screening. That'll give us all a much better idea than something being posted on Facebook and we don't know who saw it and we don't know who commented on it or where they live, right? We want to be specific to Waukesha County. And our proposal is if we do this and we can get some sense by June 1st, if it's obvious from the returned written questionnaires that there's going to be a significant problem finding fair jurors in Waukesha County, then we may agree to the court to revisit this issue. But if 80 or 90% of them come back and it appears that we can impanel a fair jury from Waukesha County, then we can proceed with our October 3rd trial date. So that's just an idea we discussed this morning, Your Honor. And that's why I suggested maybe we set the trial date and work backwards with that type of logic.
There is precedent for that as well in Waukesha County.
Yes.
And that, of course, is related to the Slender Man cases. While I was not presiding over that case, I was fully aware and at times involved in the planning, and jury questionnaires were utilized. That was a case where everyone expected it would take a week to impanel that jury, and it took a day. And I think in large part due to the jury questionnaires. So that's, I think, an excellent idea. I know you're hearing about that for the first time, but I think that's also a really good gauge, perhaps the best gauge, to find out if a jury can be seated from Waukesha County. So I do like that idea. And it would still give us ample time.
Yes, if it's obvious, then we could still talk about bringing in a jury from another county. We'd still have several months to arrange for that, Your Honor.
We obviously would need to work very quickly to develop that questionnaire, and we can certainly do that. Parties can work, of course, outside a court hearing to do that, but we can have a very lengthy court hearing as well to discuss any objections or questions. We have sample questionnaires certainly from that case, started to pull that information, so we're prepared for that, and I think we could do that in short order.
I do too.
Attorney Perry, anything on that?
I don't know if the court is thinking about just ordering that procedure this morning as opposed to the standard for granting change of venue, which is if there's a reasonable likelihood that a fair trial cannot be had, or if this is something that the state is previewing for its response to our motion. But of course, this is the first that we're hearing about that suggestion.
It is a well thought out suggestion, and I would like to pursue that before having to decide the change of venue motion. So I will work with the parties to make sure we do that as quickly as possible. I will work with our clerk of court to provide questionnaires that we did in the Slenderman case and other cases. It's not the only time we've done questionnaires to get an idea. Of course, the parties can look at that and make recommendations. I think we should come back quickly, though, and make this a priority for everyone to finalize that questionnaire so that it can be out within about a month or so's time. I think we can realistically do that, though. I do have, because the trial just came off, Tuesday, March 29th, all day available, where we could have a hearing on the jury questionnaires. And that gives the parties some time, not a lot, but some time to put together their proposals. Is that doable for the state,
Yes, Your Honor.
for the defense?
That's fine.
I think we need an entire morning to go through that process. Attorney Hopper?
I think that's safe to block that time. I don't know that we'll need it, but
Maybe
we would
start at
start
9 a.m.?
Sure.
9 a.m. on the 29th, does that work for the defense team as well?
I do currently have a trial scheduled for that morning. I have requested an adjournment on that trial that has not yet been granted, so I don't know for sure what the status of that trial will be that day.
Let's schedule, and of course, if that is not granted, then we can look at another date, but all right, so Tuesday, March 29th, 9 a.m., we'll block it off for 3 hours, so the morning, I would need I will work again with the clerk's office to get things out, if not by today, early next week, with sample questionnaires. I would like the parties to file any proposals related to that by the 25th. That's the Friday before.
Yes, Your Honor.
So with the court's determination on that, I will continue to hold in abeyance and under advisement the motion for change of venue. All other dates I think that I would need to establish, I will just do in the trial order. I'll get that uploaded. That will have due dates for exchange of witnesses, lists, naming of any experts, pretrial motions, etc. We'll also have a due date if there is to be any resolution short of trial, well in advance of the trial, so that, of course, I can release that time. Since we're going to be coming back on the 29th, if there are any issues as you look through your calendars with any of the due dates, I can address kind of adjusting at that point in time. All right, anything else the state thinks I need to address today?
No, Your Honor, thank you.
Anything the defense thinks I need to address today?
No, I don't think so.
All right, very well then, thank you. We are concluded then, and we'll see everyone here on the 29th at 9 a.m. I will continue to live stream.